Hi, I'm Jay Pink. I'm an attorney, Modesto, California. I'm here to tell you about the history of probate in California. Did a little research in the subject, thought I'd share about it. Started back in 1511 in England when King Henry VIII was realizing he wasn't getting enough money from the death taxes in his country. So he passed what's called the Statute of Uses. And essentially, it's come down since America has the common law that came over from England, essentially the same law. At the time, that said that when you die, the king owns all your stuff, all your land, and he'll find out who you owe money to, sell what he needs to sell to pay that debt. He'll find out who your heirs are, your firstborn male son or the like, and then he'll take his share from the taxes and then pass it out to your heirs, what's left. And it's the same system today, except instead of the King of England owning it, it's a California court system. They don't really own it, they just control it and make you jump through all the hurdles of what's called the probate system to ensure that who you owe money to and that those people get paid, who your real heirs are, and that they're going to stand to inherit. And then once the court is wrapped all that up, they assign the fee, the statutory probate fees, and you can see those on our firm's website. And then they let you distribute it. Problems with probate today are that it's slow. The court has to oversee the whole thing. Takes a year, 18 months, easily. That's with no contested issues. Second, it's expensive. That fee I mentioned is very expensive to the heirs that have to be paid, and that fee gets paid to the law firm that helps with the probate, and then it can get paid again to the trustee the executor of the probate, if you don't have a family member that's going to do it for free. And third is it's public. I know title company people, they go to the probate courthouse every Friday. They request all the probates that were filed that week. They can see the will, they can see the addresses, they can see the phone numbers, they can see who the executors are, how many kids they had. And then they document all this information and blast it out on an email across town to different realtors. And the realtors can cold call these people and say, I'm sorry for your loss. I'd like to sell the house for you. And they tell me that if the will disinherits a child or something, they'll leave that one off their list because they don't want to be sharing drama with their contacts. So I do not want you, my clients, to be on that email list to the realtors across town with your drama being shared. So the ways to get out of probate, there's a few. Primary one being a revocable living trust. Things that you own in your trust are not included in probate. The idea of probate is that whatever you own in your name when you die goes through probate. Well, if things are owned by your trust, when you die, you can just say, I don't own it, my trust owns it. We call it a little legal fiction because your whole life you've owned these assets, you've controlled them, you've bought and sold them, you've paid taxes on them. Just at the time of your passing, you can tell the probate court, you don't need to get involved here. It's owned by my trust. My trust hasn't died. It's still alive. It's a legal vehicle. Another way you can get out of probate are certain assets are just exempt from probate. Retirement accounts, for example. Those have their own body of law that pass contractually through beneficiary designations, life insurance, and the like. And also contractually, you can pass certain assets like through joint tenancy or a joint bank account that automatically goes to the other named person when one passes. Now there is some paperwork to file, and like always, this video is just general legal information not to be taken directly for your case, for your specific facts and scenario. Definitely meet with your own attorney and get counsel. All right, hope you enjoyed quick history on probate, California.